Hello, welcome to today's immigration tidbit. Yes, your 21-year-old, I assume is a U.S. citizen, can petition you. It's irrelevant whether you're married or not. If you are the biological mother of this 21-year-old, your 21-year-old can petition you. Now, the next question is whether you can adjust status in the U.S. If you're inside the U.S., then we would need to know if you entered legally or illegally. If you entered illegally, then I would need to know when you entered. And while your 21-year-old can still petition you for what's called the I-130, you won't be eligible to adjust status in the U.S. and you would have to leave the consular process. The problem with that is that you would be subject, assuming you've been here more than a year out of status, you would be subject to the 10-year bar, which one normally would need to do a waiver of the 10-year bar. But in order to do the waiver, you have to have a qualifying relative of which a son or daughter is not. And assuming that's the case, then you don't qualify for the waiver, and theoretically, you're not going to wait outside for 10 years in order to go forward. There might be some other ways of doing it, assuming you fall under this category, such as a humanitarian parole. I'd need to know maybe your son or daughter was in the military and you can do a parole in place or a PEP application. However, if you did enter legally, you have no deportation orders, and then you likely would qualify to adjust in the U.S. as an immediate relative, and your son or daughter can not only petition you for the I-130, but can concurrently petition you for the 485 adjustment application. So I'd need to have more facts to know how to help you, but it looks like it's doable depending on how you entered the U.S. and so forth. Okay?